Starting April 17th, a unanimous 9-0 Supreme Court ruling changed the legal rules for retirement plan lawsuits nationwide. And the U.S. Department of Labor says ERISA-covered plans touch 155 million workers, retirees, and dependents. If you have a 401k, a 403b, or a private employer retirement plan, this decision could make it easier to challenge excessive fees, conflicted deals, and weak oversight before more of your savings disappear. In this video, you'll learn what the court changed, who is affected, who is not, and the exact steps you should take now to protect your retirement money. Let's get into it, starting with the part most people miss. Source. There is one specific sentence in the Supreme Court's opinion that changes the pressure on retirement plan managers in all 50 states. And I'm going to read that sentence word for word near the end. Most people never see it. But once you hear it, you will understand why this was not just another technical court case. It was a rule change about who has to prove what when retirement money is put into question. And if you miss that sentence, you miss the entire story. Source. What the court actually changed. This ruling did not raise your Social Security check. It changed who carries the burden when a retirement plan is accused of making a bad deal. Here's what changed. The case was called Cunningham versus Cornell University, and the Supreme Court said retirees and workers who sue under a key ERISA rule do not have to prove at the start of the case that every possible legal exception does not apply. In plain English, that means the person bringing the case only has to point to the transaction and say, this looks prohibited under the law. Then the plan managers and service providers have to come forward and prove why the deal should be allowed. That sounds technical, but it matters. Before this, some courts were forcing workers and retirees to clear a much harder hurdle right out of the gate. Now the Supreme Court said the standard must be read the way Congress wrote it. Source. Here's what it means for you. If you are in a private workplace retirement plan and you suspect the plan was loaded with unnecessary fees, overpriced services, or insider-friendly arrangements, courts may now be more likely to let the case move forward instead of throwing it out immediately. That does not mean every lawsuit wins. It does mean plan fiduciaries, the people legally required to act in your best interest, may face more pressure to explain themselves. A fiduciary is simply the person or company that must handle your retirement plan with loyalty and care. If they fail, this ruling makes it harder for them to hide behind technical pleading arguments at the very start. Source, stop. This is the part that surprises most people. The court did not say the transactions were automatically illegal. It said the burden to prove an exemption belongs to the defendant who wants that protection. That is a major shift in leverage. Here's what you must do. If you still have money in an old 401k, a current employer plan, or a 403b, do not assume the plan's fee structure is fine just because no one warned you. Pull your latest plan disclosure and look at who is being paid. And remember, this connects directly to that one sentence from the ruling I'll reveal at the end. So, what does this mean for you? It means retirement plan managers may now have a harder time escaping scrutiny at the very start of a case. Source, who is affected and who is not. This ruling matters nationwide, but it does not hit every retirement benefit the same way. Here's what changed. Because ERISA is a federal law for private sector retirement plans, the Supreme Court's reading applies across the country. SCOTUS blog noted that pleading standards for ERISA should be the same nationwide, and that is why this ruling matters in all 50 states. If your retirement money sits inside a private employer plan, the legal playbook just became more uniform. No more one standard in one court and a tougher standard in another. That is important because retirement savers should not lose protection just because they live in a different state. Source. Here's what it means for you. If you have or had a private sector 401k, a 403b run by a qualifying private nonprofit employer, or certain private pensions, this ruling is relevant. But if you receive Social Security, Medicare, or a federal, state, or local government pension, this decision does not directly change those programs. I need to be very clear there because many videos online blur that line. The Department of Labor says ERISA protects private industry retirement plans, not all retirement systems. Government plans and some church plans are generally not covered. So, if you are a retired teacher with only a state pension or a city worker with only a government retirement plan, this case does not automatically rewrite your benefit rules. Source: write this down. Social Security is not the center of this ruling. Private employer retirement plans are. That does not make the case small. Millions of older Americans rolled money from workplace plans, still hold assets in them, or depend on them alongside Social Security. And if you are helping a spouse, widow, or adult child manage retirement accounts, this matters to your household too. Here's what you must do: make a list tonight of every retirement account you have. Separate them into three groups: Social Security and Medicare, employer plans like 401k or 403b, and personal accounts like IRAs. That one step will tell you immediately whether this ruling directly affects money you control. And yes, this also connects to the mystery sentence I'm revealing shortly. So, what does this mean for you? It means you need to know whether your retirement money is in an ERISA covered plan before assuming this ruling protects it. Source: why this matters to your balance. Small retirement plan fees can drain tens of thousands of dollars, and this ruling puts more pressure on plan managers to justify them. Here's what changed. AARP said fiduciary breaches, including high fee investment options and failure to monitor plan expenses, can cost retirement savers 20% or more of their nest egg. That is not a typo. 20% or more. So when a plan hires service providers, record keepers, or investment companies and the pricing looks too rich, that is not just a paperwork issue. That is your future grocery bill, your property taxes, your prescriptions, and your emergency savings. The Supreme Court did not invent that risk. What it did was make it easier for a case about suspect transactions to get through the first door of the courthouse. Source: here's what it means for you. If you have ever looked at your retirement statement and felt the account grew slower than it should have, fees may be part of the reason. Not always, but sometimes. And many retirees miss this because the charges are often buried inside fund expenses, record keeping costs, or service arrangements between the plan and outside companies. A party in interest is the legal term here, and all that means is a person or company with a close relationship to the plan. The court was dealing with whether transactions with those parties can be challenged without retirees having to disprove every exemption before the case even gets going. That is why this ruling matters. It is about accountability. Source: rhetorical question. If your plan is paying reasonable fees for necessary services, why should workers and retirees be blocked before the facts even come out? That is exactly why this decision has retirement lawyers and plan sponsors paying attention. Here's what you must do: look for your plan's annual fee disclosure, investment expense ratios, and any notice about record keeping or advisory charges. Compare what you see now to what you saw 2 or 3 years ago. If the cost climbed and no one explained why, flag it. If you no longer work for the company, you can still request records for plans where your money remains. And keep watching, because the exact sentence I'll reveal in a moment explains why the burden now lands more directly on the people defending those fees. So, what does this mean for you? It means even small retirement plan costs deserve your attention because they can shrink your savings far more than most people realize. Source: what retirees should do right now. Waiting for your plan administrator to volunteer bad news is a mistake. Here's what changed. The Department of Labor says its Employee Benefit Security Administration recovered $1.4 billion in direct payments to plans, participants, and beneficiaries in fiscal year 2025. That tells you two things. First, retirement plan problems are real. Second, government oversight does happen, but usually after damage is already found. This Supreme Court ruling does not replace your responsibility to review your own plan. It gives retirement savers and their lawyers a stronger opening position when suspect transactions are challenged. Source: here's what it means for you. If you are retired, near retirement, or helping a spouse with retirement accounts, this is the moment to get organized. Pull your latest summary plan description. Review any fee disclosures. Check whether your money is still in an old employer plan that may have higher costs than an IRA rollover would have. If you are in a current workplace plan, ask in writing who the record keeper is, what the total plan fees are, and whether lower cost share classes or investment options were reviewed. Use plain language. You do not need legal jargon. Ask, what am I paying? Who is getting paid? And how often are those costs reviewed? That is the heart of this case. Source, stop. This is the part most people miss. You do not need to wait until your account crashes to start asking questions. A pattern of unnecessary costs over years can do damage quietly. Here's what you must do: save statements, save plan notices, save emails. If something looks off and the responses are vague, you can contact the Employee Benefits Security Administration for guidance. And if you are in a private plan that seems packed with high cost options, ask whether the fiduciaries documented why those choices were reasonable. That one question alone can change the conversation. And yes, it ties directly to the sentence I promised to show you. So, what does this mean for you? It means the smartest move now is to review, document, and question your private retirement plan fees before more money slips away. Source. Here is the sentence I told you to wait for. The Supreme Court wrote, the court holds that Fairborn Woman 8 sets out affirmative defenses, so it is defendant fiduciaries who bear the burden of pleading and proving that a Fairborn Woman 8 exemption applies to an otherwise prohibited transaction under Fairborn Woman 06. In plain English, that means the retirement plan managers and related companies have to prove why the deal was allowed. The retiree or worker does not have to knock down every possible excuse before the case can even start. That is why this ruling matters across all 50 states. It sets one national rule for ERISA pleading. This is the part I want you to screenshot or write down, because this affects your check directly. Not your Social Security check, but the retirement balance that may decide how much monthly income you can safely take for the rest of your life. Source. Before you go, I have one question for you. Have you ever looked at a 401k, 403b, or old employer retirement account and felt like the fees were impossible to understand? Tell me yes or no in the comments. I read every single one, because the next video I'm releasing covers the biggest mistake retirees make when rolling over an old 401k into an IRA. And if you're not subscribed, you will miss it. Hit subscribe now so YouTube notifies you the moment it goes live. Also, go back to Fork Hour in this video. There is one detail I mentioned that most people miss on first watch. Now that you know the full picture, it will hit differently.